Welcome to Planning for Protection.
Welcome back to Planning for Protection with attorney Jeff Ryder. Jeff is an elder law and estate planning attorney serving families across Carroll County and the surrounding Indiana communities. I'm Evan Mack, and today we're talking about Medicaid planning for married couples in Indiana and the difficult financial decisions families often face when one spouse needs nursing home care. Jeff, welcome back, sir.
Thank you, Evan. It's good to be back.
Good stuff. So, Jeff, what changes legally and financially when one spouse needs nursing home care, but the other spouse is still living independently at home?
Well, that can be a very life-altering juncture in time because the cost of care is so expensive. I regularly see anywhere from $8,500 to $14,000-$15,000 per month in care costs, and not very many families are set up to, cover that cost without, liquidating what they might have worked all their lifetime to achieve.
Indiana Medicaid rules treat married couples differently than single applicants. What protections exist specifically for the spouse who remains at home?
Well, fortunately, the Congress has passed the Spousal impoverishment, which essentially say the spouse, if there's a community spouse at home, they don't have to use up all the resources and assets to get this care their institutionalized spouse needs. There are protections built in that will allow the ownership of assets to be shifted to the community spouse.
A lot of couples worry they will lose savings they spent decades building. How does Indiana determine which assets the healthy, spouse is allowed to keep?
These rules are so complex and there's so many details and so much documentation needed that it's really almost essential that you have a guide working with you who knows the terrain and where the pitfalls lie and what you need to do to achieve it. So to dive into that vast topic, the federal government says that states will implement a quote snapshot date. The snapshot date is the first day of a continuous period of institutionalization for a 30-day period or more. And so sometimes we have very historic dates because they had a fall 10 years ago and they went into the nursing home for some rehabilitation and it took more than 30 days between the hospital and the nursing home. Many times it's more recent, they just got admitted to the hospital and transferred to the nursing home. But whatever that snapshot date is, you take an imaginary camera and you take a picture of all the assets of the couple, both husband and wife or joint with any children, as long as one of the spouse's names is on that asset as an owner, and see what the value of all those countable assets are on the snapshot date. Some assets are not countable, other assets are countable. The ones that are not countable are the residence, if the community spouse is still going to be living there, which oftentimes is the case, and one vehicle of any value. Another thing is if you've already planned your funeral, those funds in a funeral plan or trust are exempt. But the most other assets are countable resources. So you look at the value of all those countable resources on the snapshot date, and you divide it into two, 1/2 and 1/2. The community spouse is able to keep 1/2, subject to a minimum and a maximum. There's a floor and a ceiling of what this community spouse can keep. But and those numbers change each year, go up slightly generally to reflect inflation. So there's a lot of details needed and a lot of values needed, and then we can calculate what the snapshot amount should be, and then we can spend down the other half in family-friendly ways as opposed to paying the nursing home all of that excess money above the community spouse resource allowance.
Income creates a separate layer of confusion for married couples. How are pensions and Social Security benefits or retirement income handled once the spouse enters that nursing home, Jeff?
Well, that is a very oftentimes encountered source of confusion, Evan. There's a sharp distinction in Medicaid between assets and income. And so the money coming in each month from Social Security or a pension, pension or rent is, of course, income. And that income of the community spouse is basically supposed to be paid to the nursing home as part of the, quote, patient liability amount that the patient is expected to pay each month. Medicaid would then top it off and pay the difference between whatever the patient liability amount is and what the reimbursement rate for that nursing home bed is from the state. But the income is generally supposed to go to the nursing home. There are some exceptions, though. One exception is if the institutionalized spouse has a Medicare supplement policy, the medical insurance can be deducted from the patient liability amount. So sometimes people have a kind of a Cadillac Medicare supplement plan costing $400 or $500 a month. And they're like, well, I could just drop that, couldn't I? Because this Medicaid is going to take care of that cost of those medical expenses. My advice generally is no, don't drop it, because Medicaid wants to be the payer of last resort. So they're going to allow you to keep the money to be able to pay that premium. And otherwise, you're going to be paying it to the nursing home. So you're going to pay it one way or the other, but you might as well go ahead and keep the Medicare supplement plan to have three layers of coverage: Medicare, the Medicare supplement, and Medicaid. A lot of times, the surviving spouse says, the community spouse says, I don't know that I can pay my bills without the income of the spouse in the nursing home. Fortunately, there is a spousal income provision where the institutionalized spouse can shift some of his or her income to the community spouse still at home to allow them to have more income to be able to pay their bills. And those numbers change each year, but we can always provide the updated numbers for what the community spouse is allowed to have as an income allowance from what the community spouse is allowed to have as an income allowance from the institutionalized spouse.
So married couples often own homes, farmland, retirement accounts, or investment property together. What planning concerns tend to become more important when long-term care enters the picture?
Well, that's a very good question. So in Indiana, income-producing real estate is considered to be an exempt resource for application purposes. So we've had couples with farmland, say, and because that farmland is producing income, the state of Indiana says, okay, we will, if you transfer the ownership of that land to the spouse, then we will not consider it your income, and the spouse can have that income. So we often shift ownership of resources to the community spouse to allow them to receive the income and minimize the amount that the institutionalized person is needing to pay towards their care as part of the patient liability amount.
Some families delay planning because they assume it's too late once a spouse is already in declining health. What options may still be available even after medical problems have already started, Joe?
Evan, that's a very good question. And I encounter people from time to time who have come in and they're like, we had $500,000 and we had mom or dad in the nursing home for 4 or 5 years, and that has dwindled down. We've just got maybe 100,000 left. What can we do? It's going to run out here in the next few months, or certainly within the next year. Is there any options? And of course, my answer is it's never too late. You can always do something. So even if you don't think it's possible, come and talk to me. We can definitely develop all the options that are available to you in whatever stage of your journey you're on. And obviously, the sooner you start, the more options there are and the better result we can achieve. But it's never too late. You can always come in and get the best options available at that time.
Can you share an example of a situation where advanced planning helped protect financial stability for the spouse who remained at home?
Oh, Evan, that I get examples of that every day. I also do a lot of asset protection planning, which is also called 5-year planning, because if you have made transfers, but it's been at least 5 years since you made those transfers, then the assets are no longer, it doesn't create a penalty for you. If you have made a transfer within 5 years, you are not going to be eligible for Medicaid until after that 5-year period has elapsed from the date you made the gift. So if you are thinking about, maybe we don't want to see all these assets go towards our care in the nursing home, what can we do? There is oftentimes things that can be done to protect those, and that there's several different things that can be done. One is outright gifts, but that can also create some issues of its own, because what if there's a need that comes up within 5 years of the time you made that gift? If you just made the gift to a child, out of 3 or 4 children, 1 or 2 or 3 of them are going to have already spent the money, and they're not going to be able to return the money if there is a care scenario that develops. So we often recommend the use of trusts to hold the money that you might want to protect. And those trusts are generally irrevocable asset protection trusts. So we would create those trusts, transfer some of the assets to those trusts, and get that 5-year clock ticking so that you have a chance to have those assets protected once you get beyond the 5-year look-back period.
Family dynamics can become complicated during these situations, especially when adult children become involved in the financial decisions. What kind of misunderstandings or conflicts tend to arise?
My goodness. There is, of course, infinite possibility of conflict. And so my goal in working with a family is usually to develop as much cohesion as humanly possible. We try to get everybody to buy in. And I thank God that, many, many times that is very achievable, even in a step-parent situation. And so whatever the wishes of the institutionalized person and their spouse are, hopefully they are on the same page. We can achieve through some family planning, and we can do family agreements that provide, if there are shifts of ownership to a community spouse, that community spouse is going to honor the wishes of the institutionalized spouse to see that assets go the way that they've agreed they should go. And it's very possible to do that through estate planning for the community spouse that preserves those wishes of both spouses.
For a married couple listening right now, what signs usually indicate it's time to sit down with the elder law attorney such as yourself before, a care crisis develops?
That's a very good question, Evan. So I see a range of people. I would say people thinking about trying to protect assets are usually at least in their 50s, maybe 60s, certainly 70s and 80s, even 90s. I've had some people come, but it all depends on your health. If you are, a picture of health, you have no medical issues, no chronic diseases, you've obviously got more time. On the other hand, if you are seeing some, chronic diseases creep up, diabetes, heart disease, all these things, potential dementia, it's never too early to begin planning. And if you've got, typically on these irrevocable trusts that we create, one or more of the children are the trustees. And so if you've got a trustworthy, honest, dependable child, you're very blessed, and you could think about having that child be a trustee. And if you have that, it's not all that scary to give up some control of the assets, because that is what's required generally to get that protection started. And that control is very hard to give up for people. But if you've got a very trusted person that's working with you as a trustee, it's much less scary. And as you get older, your habits become more settled, and that you spend about X amount each year, and that you get so much income, and so your need to dip into your savings is going to be, predictable, somewhat predictable at least. And you don't have a long bucket list of things. Oh, I want to spend money on the trip around the world, or I want to spend money on the vacation home in Key West, or I want to buy the sailboat or whatever. If your expenditures are fairly predictable, it becomes much more feasible to create these asset protection strategies that will allow you to protect the resources that you don't think you're going to get spent during your lifetime, and you would hate to see them spent at the nursing home. So it's never too early, but I see a lot of people probably from 50s on up that are thinking about these issues.
Good stuff, Jeff. Thank you so much for your time.
Evan, it's a pleasure. Thank you, and have a great day.
All right, you too. That's it for today's episode of Planning for Protection. If you'd like to learn more about attorney Jeff Ryder and his work at Jeffrey C. Ryder, Attorney at Law, LLC, visit jryderlaw.com. Thanks for listening, and don't forget to like, leave a review, and share this episode with someone who might find it helpful, and we'll see you all next time.
Thanks, Evan.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.